Hello, in this video, we are looking at remoteness of damage, And we want to determine in the case of tort of negligence, having realized that a damage has taken place, what is the relationship of that damage to the breach of duty of the defendant? Is the damage what you'd expect from the breach of duty or not? In this context, we are not trying to determine if the defendant is factually responsible. That must have been settled in the affirmative. The defendant is factually responsible for the injury to the plaintiff. We have also excluded the question of novus actus intervenis, a break in the chain of causation. That issue may not have arisen, or it has arisen and it has been expended. Here in this presentation, what we are trying to look at is how the law puts an end and limits liability and says, oh, for instance, this injury that has occurred cannot be a reasonable result of the breach of duty. And in that context, we intend to look at the issue of remoteness of damage in the context of what is called, sometimes in some texts you see descriptions like causation in law, and they try to discuss the principles under causation in law. Some will limit it to issue of remoteness alone and leave and ascribe causation in law to the question of whether there is a break in the chain of causation. Approaches may differ on what is construed as remoteness of damage. And as by way of an overview, I wanted to take note of this statement where Lord Wright tried to explain what we mean by remoteness of damage and says that the law must draw a line somewhere because it cannot take account of everything that follows a negligent act. Some consequences must be extracted as relevant, not on grounds of pure logic, but simply for some practical reasons. So sometimes, in practical terms, the law may say that there is no liability, that the damage is too remote, it's too far-fetched, it's too far from the initial act. Now, the learning outcomes for this presentation are threefold. To understand the meaning of remoteness of damage, what in American jurisprudence is referred to as proximate cause, and what you are trying to look at in remoteness of damage is the scope of liability in the tort of negligence. Is it still within the scope of foreseeable injury, what the plaintiff has experienced? And in order to do this, we want to also appreciate the nature of the injury and why the rules of remoteness of damage exist. Thirdly, you understand and apply the rules relating to legal causation in a tort case. Now, the explicit and narrow question that this presentation attempts to answer is whether this damage suffered by the plaintiff is a reasonably foreseeable consequence of the negligence of the defendant. Is the damage a reasonably foreseeable consequence of the breach of duty by the defendant? We note that we are adopting the approach that factual causation and legal causation has been established already. By legal causation in this context, I mean that there is no novus actus intervenis that has been established. Now, the law tries to set a limit to liability. Imagine if someone were to be found in a situation where the injury that they caused, they are made liable for everything that results from it. For instance, a defendant D injured P in an automobile accident, and B has injury to his body. Maybe he was burnt and cannot even be recognized, and they had to do plastic surgery. It is reasonable to say the defendant is liable for the personal injury to P. But assuming that because of that accident, of that breach of duty, and the injury that happened to P, P's wife leaves him, and says, I cannot cope with a man like this. And P loses his job, and the wife lives with the children. So the marriage breaks down, and she goes ahead and obtains a divorce. Can we say, for instance, that the defendant should be liable for the break for the breakdown of that marriage? Can we say that it's because the injury that he caused, it's also what made the wife to leave, and so he should be given damages for the loss of his marriage? So the question is whether on any sensible bill, there's only one true cause of the claimant's loss. Not can we say that looking at the facts of the case that we have presented, for instance, is the loss in question a very unusual result of the defendant's conduct? The fact that the wife left the plaintiff. So you're not asking whether there are alternative causes of the conduct. When you are talking about alternative causes, that is taken care of in the issue of, for instance, novus actus intervenis, that there's some other causes that have taken place and they are broken chain of causation. Here, you are not saying there are alternative causes, but you are saying that the very cause that the plaintiff has experienced, which we say the defendant is responsible, is it reasonably foreseeable, or is an unusual result, a weird result, an uncommon result, so to say? And when you do that, you go into the realm of remoteness of damage. So remoteness is about scope of liability. What is the risk that you have created? What is the breach of duty? Okay, you have, if you are driving negligently, the risks of personal injury, injuries in property are explicit. Or is it foreseeable that when you have caused injury, for instance, to that person, and the person is taken to the hospital, that that person can be a victim of poisoning by the nurse, or negligent treatment by the doctor, or wrong prescription? So how do we break responsibility and say this is where responsibility starts and this is where it ends? It's about scope of responsibility or scope of liability. And you inquire onto the issue of remoteness of damage after you have gone past factual causation and or legal causation, in cases that we say legal causation relates to novus actus intervenis, for instance. So the remoteness of damage looks at the damage. It's not looking at who is the claimant, who should be the defendant. It's looking at the damage to see this damage, is this reasonably foreseeable? The death of the man that fell off a platform, the fact that somebody was injured in their leg and they have a broken leg and they are taken to the hospital, and while they are there, they are shot by robbers. We have examined some of those cases in earlier presentations. But in these presentations, we are taking off, look, this particular injury before the court, is this a reasonably foreseeable injury? Someone is injured in the mouth, is injured in the leg. You can reasonably foresee, I can cause personal injury by your driving, for instance. But can you reasonably foresee that that personal injury can develop into something else? What can it develop into? So those are some of the things this inquiry is about. So it's not an inquiry about multiple causes or alternative causes, which we have looked at in factual causation. It's about is the question about the injury that you have suffered. Should it be ascribed to the defendant, or it should not be ascribed to the defendant? So the general rules of legal causation or remoteness of damage, depending on the terminology that we are trying to adopt, is that the defendant is only liable for reasonably foreseeable damage. Reasonable foreseeability is critical, not only for duty of care, not only for breach of duty, but also for remoteness of damage. It's only what is reasonably foreseeable that you can hold the defendant liable for. But it has also been said that it doesn't mean that it will be reasonable, it will be liable for all damage that was reasonably foreseeable. Sometimes there may be reasonable foreseeability, and the court on policy grounds also still hold that there is no liability. Now, there are approaches that you will find in major texts and discussions in this field. Hitherto, the case of Remoteness was the approach that the courts used, which says that a defendant is liable for the direct consequences of his actions. Whether they are foreseeable or not foreseeable is immaterial. Later, you have the case of Overseas Township UK Limited against Mound and Engineering Company Limited, popularly called the Wagon Mound. The Wagon Mound. And this case is, pardon me, established defense rules. In Remoteness, the issue concerned a situation where the defendants had chartered the plaintiff's vessel for the purpose of carrying benzene. And when they chartered the vessel, in the course of using the vessel, some of their employees negligently dropped a plank into the hold, and this erupted into flames, of course, coming in contact with the benzene, which had leaked to the vessel, and the ship was destroyed. The Court of Appeal held, the English Court of Appeal held that they were not, it was not foreseeable, quite all right, but there was still liability because it was a direct consequence of the actions of their staff. Yeah, it was a direct consequence of the actions of their staff. Because of that, whether it was foreseeable or not, they were held liable. So direct consequence was established as the basis of liability. And that was the case as far back as 1921. Later in the Wagon Mound, the rule about direct liability was examined and replaced by what is called reasonable foreseeability rule. Now, what happened in Wagon Mound 1? You have Wagon Mound 1 and Wagon Mound 2. Wagon Mound 1 concerned a situation where plaintiffs sued the defendant for damage to their vessel, to their wharf, because defendants had they chartered a vessel, the Wagon Mound. It was an oil vessel that was carrying oil, and it was battered at Sydney Harbour. Through the act of the negligence of their staff, oil from that vessel spilled, a large quantity of it spilled on the water. And eventually it combined, when it spilled, it spread from where the ship was battered in Sydney Harbour and spread to the plaintiff's wharf about 600 meters away, where the plaintiffs were carrying on welding operations on another ship, the Corriman. They were carrying on welding operations on that ship. When they saw the oil drifting into their harbor, they stopped welding operations and asked the defendant whether there was a risk of fire. And the defendant said there was no risk, that they could continue their work. 2 days later, the place caught fire, the wharf was destroyed, and the ship also was destroyed. The Corriman was destroyed. How did this happen? Some cotton waste floated onto the oil, and when that oil, cotton, of course, mixing with the oil on the water, came in contact with sparks from the welding, ignited a fire and destroyed the properties involved. And the question was whether there was liability. We applied the Remoteness test that we talked about. Of course, the direct consequence of the oil spillage was what happened, and they would have been liable. But the court held on the fact that it was not reasonably foreseeable that when oil pours on water, fuel oil, that it would cause a fire. Nobody foresaw the interface of the cotton waste coming onto the oil, mixing with it, and igniting with the sparks. Since it was not reasonably foreseeable, the damage, the defendants were not liable. And by that decision, the Privy Council overruled the case of Remoteness. Now, Lord Simmons stated that it does not seem consonant with current ideas of justice or morality that for an act of negligence, however slight or venial, which results in some trivial foreseeable damage, the actor should be liable for all consequences, however unforeseeable and however grave, so long as they can be said to be direct. So he tried to criticize the direct consequence test of Remoteness and said, look, it means that you can even be liable ad infinitum as long as you can say that is a direct result of what has happened. For example, like the one I said about the man that was suffering had personal injuries and the wife has left him. It's a principle of civil liability that a man must be considered to be responsible for the probable consequences of his act. To demand more of him is too harsh a rule, and to demand less is to ignore that civilized order requires the observance of certain echoes of conduct. Therefore, in the light of that decision in the Wagon Man #1, reasonable foreseeability was established as the test for remoteness of damage. And if you look at the Wagon Man #2, a different finding was made a few years later when it was decided, where action was brought by the owners of the vessel that was under repair that was damaged in the Gulf. In that case, different findings of facts showed that it was reasonably foreseeable. Fire was reasonably foreseeable, and they were held liable on the facts. So you will take note of Wagon Man #1 and Wagon Man #2. Now, in the light of this reasonable foreseeability test, some principles have emerged. Some principles have emerged. One of the principles is that the kind of type of class of damage that's happened must be reasonably foreseeable. What kind of damage was foreseeable? Property damage was foreseeable. A personal injury was foreseeable. What kind of injury, what kind of risk do you create? I mentioned Lord Hoffman's example in the Samco case in earlier presentations, where he gave the example of a person that wants to go on a mountaineering trip, and he goes to his doctor and says, check me out, I have legs to climb. And the doctor says, it's okay, you can actually go on that trip. Your legs are fine. And it turns out that when he gets on the trip, he suffers an injury because his legs collapse. What is the risk of not being properly certified? If it's because the legs collapsed and he fell, then it is a risk within the scope of risk that is created. The risk that is created is personal injuries. He could be injured. But the law requires, therefore, that the type of injury damage that you've foreseen is the one that must have happened. The Wagon Man #2 establishes the fact that it was foreseeable that fire would ensue, and fire was what happened. And like I said, different findings of fact between #1 and #2. Now, the law is concerned with the fact that the injury is foreseeable. It is not concerned with whether it is not concerned with the extent or the manner of occurrence. So if it is foreseeable that personal injury can occur, how it happens is immaterial to the law. How it happens is immaterial. In Hughes against Lord Advocates, where post office employees had left a manhole unattended, and they surrounded it with liquid paraffin lamps, probably to prevent people from getting near the hole. And a child went near the hole, saw the lamps, picked it up, and in the course of playing with the lamp, dropped it, and it fell into the manhole, causing an explosion and injury to the plaintiff, to the child. The court held that it was foreseeable that when you leave lamps hanging around on a public space like this, children could actually play with it and they could get burnt. How that burn occurred, in this case, falling into the hole with the lamp and exploding, might not have been foreseeable, but it was reasonably foreseeable that there was a risk of personal injury. Then you have Jolly and Sutton, where a child was injured when he was playing with an abandoned book that the defendant had left on their property. That property was accessible to the public. And so the court said that defendants should have reasonably foreseen that children could actually come and play with an abandoned boat, and realizing the propensity of children to do mischief, not only to themselves, but also to others. And that, like what Hoffman said, that they were liable. You have, so the extent, the manner of occurrence need not be foreseeable, like we said, And the extent of the harm also need not be foreseeable. Use and Lord advocate that we have talked about earlier, the extent of injury is immaterial. Once the injury was foreseeable, how wide the injury has gone, how deep, how, it's immaterial to the law. That's why that, even though it caused an explosion that was not foreseen, the court and the explosion caused personal injury. The court held in use and Lord advocate that personal injury was foreseeable, and that was what happened. It was immaterial the extent of the harm. In Vacal Engineering Chemicals case too, where the plaintiff purchased chemicals from the defendant, but it was not warned that the chemical must not come in contact with water. The plaintiff put the chemical in a zinc, and there was a massive explosion which caused personal injuries to the plaintiff. Defendants were held liable for the explosion. It was immaterial that they did not envisage the magnitude of the explosion. But it was clear that if it came in contact with the chemicals came in contact with water, that it could cause a burn, an injury. And that was what was the basis of the decision. Then you have Freeman and Pike, a situation where the defendants were running a farm, and then the plaintiff was working for them in the farm. The farm was infested with rats, and the defendants and the plaintiff was exposed to these rats, and he caught Wales disease while at work for them. This is a rare disease caused by the exposure to the rats, and the court held that that was a very rare disease. It was not reasonably foreseeable that it would catch that disease. It was reasonably foreseeable that it would have rat bites or rat poisoning, food poisoning from exposure to rats, but that Wales disease was a very uncommon, unusual result of that exposure. So it was not reasonably foreseeable. Now, in discussing these rules on reasonable foreseeability, I want us to take note of the eggshell skull rule. This rule can come into play. It doesn't mean that every fact that you have before you look at the eggshell skull rule. It is if the facts illustrate or depict the fact that there is eggshell skull principle. Eggshell skull rule is situations, of course, it's just over, where you have first, I must know that there were concerns after reasonable foreseeability was established in Wagon, Mound, whether that rule continues to exist. The rule requires that a defendant who causes injury to a plaintiff is going to be held liable for that injury if the injury was foreseeable. For instance, personal injury, even though the consequences of that injury were not foreseeable. The consequences were unforeseeable. It's normally reflected as take your victim as you find him, but it means really that you take your victim as you find him only with respect to the fact that if you can foresee that if I give chemicals to this person, it can cause personal injury to him, and it actually causes personal injury to that person, then that person is like to be liable for the personal injuries. Now, if the personal injuries develops into something else, which you did not foresee, you cannot escape liability. You take your victim as you find him. If it develops something else because of the personality of the victim, because of his health status, because of his peculiar health or physiological makeup, it does not lie in the mouth of the defendant to say that I did not foresee that the initial injury would develop into what it has developed into. So, Winfield and Gilowitz said the requirement of reasonable foreseeability applies to the claimant's initial injury. So, provided that the initial injury was of a kind that was foreseeable, it is irrelevant that the consequences of that injury were of a different unforeseeable kind. Now, you see these principles stated by Kennedy J. Dooley and White. He said, when a man is negligently run over or otherwise negligently injured in his body, it is no answer to the sufferer's claim for damages that he would have suffered less injury or no injury at all if he had not an unusually thin skull or unusually weak heart. So it's thin skull, eggshell skull, weak heart principle, depending on how you want to look at it. You cannot argue that it's because he's a weakling. That's why his injury began to develop into something else. It does not lie in the mouth of the defendant. So to this extent, we say you take your victim as you find him, as regards the victim's physical or psychiatric condition. The Smith and Brain and Co. is a good case to illustrate the eggshell skull principle. The defendant's negligence has caused, a plaintiff to suffer a burn, was burnt in the lips because of exposure to some chemicals. And the exposure caused him to have a burn on the lips. It was reasonably foreseeable that that injury would occur. But this now triggered a cancer because he had a pre-malignant condition that exposed him to, that triggered a cancer as a result of the burn, and he died. The court held that the burn was a reasonably foreseeable consequence of the breach of duty by the defendants. And once that burn was a reasonably foreseeable injury, the fact that cancer was not foreseeable is immaterial. It emanated from an injury that was reasonably foreseeable, so they would be liable. You may also see the case of Robinson against Post Office. Now, it is therefore important that we note the meaning of the eggshell skull rule. The initial injury that occurs due to the plaintiff's breach of duty must have been reasonably foreseeable. And then you now say, well, once that is reasonably foreseeable, whether the plaintiff is abnormally sensitive or has a peculiar condition that exposes him or that injury to further damages is immaterial. That will not be regarded as too remote. For instance, the case we talked about just now, Smith and Brain, cancer was not reasonably foreseeable, but it derived its derivative from the injury that was, reasonably foreseeable, the burn, and the court held him liable for that. We also see the case of Page and Smith and White and Chief Constable of South Yorkshire Police that we discussed about respect to the Hillsborough litigation in earlier videos. And in those cases, the courts decided to treat, in these two cases, personal injuries as a single form of injury that was not divisible. That once you can find that personal injury is reasonably foreseeable, it is immaterial whether that personal injury is physical injury or psychiatric injury. It will be regarded as a reasonably foreseeable consequence of the defendant's breach of duty. Now, you must take note of this principle. If no damage was reasonably foreseeable to a person of normal sensitivity, normal phlegm, normal attributes, if no damage was reasonably foreseeable, defendant would not be liable for any damage to the person. It is not part of the eggshell skull principle to hold someone liable for a damage that was not reasonably foreseeable. The damage that occurs as a result of the breach of duty must be reasonably foreseeable. But after that damage has occurred, if other factors come into play that maybe, for instance, extended the damage that caused unforeseeable injury emanating from that damage that was foreseeable, then we apply the eggshell skull principle to say, look, you take your victim as you find him. Now, if you, as a component of the eggshell skull rule, if you cause injury to someone that is, for example, economic injury, and that economic injury occurred because of the fact that the person is a very wealthy person, person is driving a very expensive car, for instance, and you drove negligently and run into the car. It doesn't lie in your mouth to say, why is he driving an expensive car like that? If it was a normal average car, my damages would not have been so much. It also does not lie in your mouth as a defendant to say that. So it's not expected that you must foresee the enormity of the financial loss. It's not necessary. Once it is reasonably foreseeable that if I don't drive well on the road, for instance, I can cause damage to another person's property. The extent of that damage in terms of the financial status of that person is immaterial to the law. Then there is what we call the issue of economic loss. And in Lisbrook, Dredger against Edison, that we normally call the Edison, the court held in that case that a plaintiff must be ready to bear his own impecuniosity. If your loss is expanded because of your inability, you lack financial resources to mitigate your loss. That aspect that expanded the loss cannot be ascribed to the defendant. Here in the plaintiff, in this case, lost his vessel because it was sunk by the negligence of the defendant, and he tried to sue. Yes, sue for the loss of that vessel, no doubt about that. But in a situation where he was now claiming that the contract would have been able to perform because of the loss of the vessel, he couldn't perform the contract. So he was claiming the economic loss in that respect. The court held that it was because of his impecuniosity, lack of money, that he could not hire another vessel to fulfill the terms of the contract. And that loss cannot be, excuse me, ascribed to the defendant. So the fact that you are unable to mitigate your loss and reduce your loss by taking the reasonable steps that are expected of a reasonable man may actually not be the fault of the defendant. Pardon me. However, that position in the Edison was overruled by the UK House of Laws in Legend against O'Connor, where the court held that the additional costs could actually be recoverable in the light of the facts of that case. Now, one of the things that we must note in the area of negligence and tort is the policy considerations that can come into play. We have said that the damage they are claiming must be reasonably foreseeable, but it has also been decided that not all foreseeable damage creates liability. Not all the damages that are foreseeable create liability. If you see Smith Steel, the British Steel PLC against Simmons, Lord Roger noted this, said it does not follow that a defendant must be liable for all the damage that was foreseeable. So we say reasonable foreseeability is a test of duty of care, and also the test of breach of duty. And we also say it's the test of remoteness. If it's reasonably foreseeable, the injury that you're complaining about, then the defendant can be held liable. But because if you noted what I said earlier, that the law must draw a line somewhere. How the law draws the line is what we are looking at. Therefore, the law also says that not all that is reasonably foreseeable is ascribable to the defendant. Sometimes just because of logic, not because of anything. Just because the law wants to draw a line, policy. So Wallace and Cam significant also in this respect, that sometimes it is reasonably foreseeable, but the court may still hold that there is liability, and there is no liability. Now, the example that I gave in the Samco case by Lord Hoffman tries to show that even when a damage is foreseeable, you don't just say because it's foreseeable, the person is liable. Is it the injury that you are talking about? Is it within the scope of loss or damage that the defendant had created? If you look at that Samco case, there was a careless evaluation of property and it played by the defendant. The plaintiff relied on that evaluation and thinking that it was proper, it was, economically wise to loan money to, the, to a third party, loan money because of the evaluation of the property that was being used as security, and he lost the money. And the defendant was being sued because of that evaluation. And the court looked at the risk and said, what is the risk that wrong evaluation created? The risk is that of lending the money without paying as much attention to that security that you said is a good security, the property that was given as security for the loan. Because there was a wrong evaluation, the plaintiff did not have paid sufficient attention to that security to evaluate it. Whereas if there had been proper evaluation and he had realized that the security was not adequate, he probably would have paid more attention to it and ensure that it got adequate security. So the sample case capped the liability, limited liability to the scope of the risk that you have created. That is the risk created. So the plaintiff would probably have, if he had loaned money, he would have taken adequate security for his money. So sample case is an attempt to provide a cap, to provide a ceiling on the scope of liability and say, let us look carefully what risks did you create by a breach of duty, and that risk, is it what happened? And like I said, many situations, look at the mountaineering example. Now, you also have the Meadows and Khan as an example where the failure doctor examines the patient, the plaintiff, and it was to identify a propensity for hemophilia. And he did not detect that propensity so that the plaintiff did not take act, not protect herself against hemophilia. So later, the plaintiff developed hemophilia and also developed autism. And the court held that his liability is limited to hemophilia because that is the scope of his breach of duty. The fact that autism was also detected cannot be ascribed to the breach of duty. So that is the cap. It provides, the sample case provides a ceiling, a cap, a scope of liability. You look at what is the consequence of this breach of duty and where does it land in the scheme of affairs in terms of liability. Now, one of the things that we must also realize is this: where a consequence is intended, it cannot be removed. It cannot be removed. If you did something and it is intended, then that consequence cannot be removed. You are taken to have intended all the consequences, whether they are foreseeable or not foreseeable. Scott and Shepard gives us the illustration. We have used the case in earlier discussions in tort, where the defendant threw his cube into a crowd, landed on A successfully took it straight and landed on B and continued until it finally landed on the plaintiff and it exploded and he lost his eyes. It was an intentional act of throwing into the squib into the crowd. It wasn't a negligent act, and therefore defendants can not argue that it was not reasonably foreseeable that it lead to the loss of an eye, was held liable. So intended consequences cannot be too remote and are not governed by the law. Now, the other point that we should note about remoteness of damage is that the role of policy tort. Policy considerations are sometimes taken. Like I said earlier, it has been held that even though reasonable foreseeability is the test and the defendant is liable for damage that is reasonably foreseeable, it also does not follow that he will be liable for all damages that are reasonably foreseeable. In some cases, the court will apply policy. And I know that when we're looking at breach of duty and duty of care, we have seen cases where the court have held that despite the fact that there is a duty of care and a breach, there will be no liability because of some policy considerations. You can see also Pritchard against J.H. Copeland Limited, which dealt with a question of dissolution, breach or attempt by the defendant, by the plaintiff rather, to claim that the breakdown of his marriage and the consequences of that breakdown should be ascribed to the negligence of the defendant, which caused him personal injuries and led to the breakdown of his marriage. The court rejected that as moving the law from the realm of tort into other areas of family law, in the sense that he was trying to claim all the maintenance and the alimony obligations that are expected of him in the family law perspective should be ascribed to the defendant. And the court said that it would not permit that on policy grounds. So in conclusion, remoteness of damage raises complex issues. These issues are not difficult to apply. In remoteness of damage, we are trying to look at the rules that the courts have formulated, and we have established from the Wagon number 1 that the test of remoteness of damage is reasonable foreseeability. When you are looking at the damage, you're not looking at multiple acts, alternative acts. We're looking at this particular damage. Multiple defendants are not easy. They are looking at the damage and saying, is this reasonably foreseeable consequence of the breach of duty by the plaintiff, by the defendant? If it's a reasonably foreseeable consequence, that is the rule that the Wagon established, number 1, and it's over. It's repealed. It's over. The direct consequence test of the Remoteness case. Having said that foreseeability is the test of remoteness of damage, the application has been, has battered different principles, has created different principles. We are saying that the rule, one of the principles that we have said is that where the damage is foreseeable, the extent need not be foreseeable, the manner need not be foreseeable, the economic considerations need not come into play, and that you must take the eggshell score principle and see if it comes to consideration in any particular case. You don't apply it to all cases, just if it arises in any case, we examine the eggshell score principle. And you also have other principles of law. We also said that intentional conducts are always, you are always liable for your intentional conduct. The consequences of an intentional conduct cannot be too remote. It cannot be too remote. Fools are fools at their peril. So even if you want to take being mischievous or whatever, it's still going to be liable. It's not too remote. We also said that while a person is generally liable for breach of duty, which causes damage that is reasonably foreseeable, it does not follow that they will always be liable for all foreseeable damage. Sometimes policy considerations may come into play. Now, that is essentially our general principles regarding removal of damage. We would then, in subsequent presentations, be looking at some of the ways that these principles can come out in questions, examination questions, or in court cases, by looking at some of the ramifications that they provide. Removal of damage becomes very important in the tort litigation for negligence. After establishing duty of care, breach of duty, damage and support, and you now want to look at whether factually the person responsible, the person that is being sued is responsible for the damage. And that's a question of factual causation where you apply the but-for test. But you also go on to do that causation and try to see whether there are reasons why, legally speaking, that person that is factually responsible should not be legally responsible. And having said that, look at the damage and see, is it a natural, a foreseeable consequence of a breach of duty? Or is it such a weird consequence, such an unexplainable consequence, such a far-reaching consequence that you can say that this is too far-fetched, this is too out of the ordinary, this is too unimaginable, a result of the breach of duty? We have also looked at some things that, some ways in which these are applied in practical terms. I'll see you at the next presentation.